Happy New Year to all of the attorneys I haven't seen this year thus far.
Happy New Year to you.
Happy New Year.
Yes.
Happy New Year, Miss Bridgewater.
Yes. Same to you, Miss Atai.
Happy New Year. I didn't
Mr.
realize you have not been here since the first of the year, Mr.
No, Mr. Cook, I've been here, but there are some new faces I haven't
Oh,
seen.
okay.
So I didn't want to miss the opportunity to welcome
I
you over to 2024.
I understand. I hope it's warmer in the preceding days.
Oh yeah. We'll have this conversation in July and August, okay?
Yeah, yeah. Well, I gotta go birthday shopping tonight. I should have done it this weekend, shouldn't I?
Okay. Yes.
Nice to do in 15-degree weather. So
I don't know about that, but okay.
yeah, I don't have any choice. So I guess they live with it all the time in North Dakota, so I guess I can do
Okay.
it once
Yes.
a year.
We should be starting very shortly, okay?
Okay.
And we have a small calendar, but I don't want to jinx it, so we're going to start very shortly. Mr. Walker,
Good afternoon, Miss Bridgewater. Happy belated MLK Day also.
yes, absolutely. Absolutely. Keeping the dream alive.
Mame, mame.
Judge will be on momentarily.
All right, good afternoon, everyone. We'll get started.
Good afternoon, Your Honor.
Hey, how are you?
Good.
Good. All right, ladies and gentlemen, we're going to begin our Fulton County State Court Expedited Accusations calendar. And this is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and the cases have been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we are able to handle such matters as bond, possible arraignment, and consideration of a possible plea offer if one has been made at this junction. What is that reset date, Ms. Bridgewater?
It's going to be January the 30th.
Okay, January 30th is our SAP reset date. I want to begin by reminding everyone that this whole entire proceeding is being live streamed as well as live streamed on YouTube and recorded, so govern yourselves accordingly. I want to also remind the defendants that you do have certain constitutional rights, the first being that you have a right to representation, and you should know who your attorney is by now. You also have a right to remain silent. Anything that you state about the facts, the circumstances, and the occurrences can and will be held against you. So again, listen to your attorneys. Okay. All right, deputies.
Okay. We have, I'm sorry, good afternoon.
Good afternoon.
Position number 1, Mrs. Dozier.
Okay. This is 24 CR 0000371F, Alexia Dozier, charged with 1 count of simple battery, pre-trial.
Yes, Your Honor. The defendant has 1 prior arrest cycle beginning in 2018, which was the defendant's last arrest on September 11, 2018 for a battery family violence. The defendant appears to have an outstanding warrant in South Fulton regarding that issue, and that warrant date is April 29, 2023. And it wasn't clear according to the GCIC as to whether that matter has been resolved and handled. But the defendant does meet the criteria for release level 1 with a 91% chance that the defendant will appear and an 87% chance that the defendant will remain arrest-free. Nothing further.
Okay, thank you.
Yes, Your Honor. And to add to that arrest for battery family violence, the defendant also has an open case in Superior Court. It's a pre-indicted case. The number is 24 PI 000352. It's a open damage to property. My understanding is the same victim in that matter. That was from April of 2023. In this case, law enforcement was dispatched to 2740 Thornberry Way, where they spoke to the victim, in this case, Larry Dozier. He is the father of the defendant. They were at their home and they had a verbal disagreement. And at that time, the defendant did spit in the victim's face. I understand that she only spit in his face, but because she has a warrant for battery family violence, she has an open case in Superior Court with the same victim as is. The state is asking for a $2,000 surety, a stay away from the incident location, no contact with the victim, no weapons, drugs, or alcohol while out on bond. And this time we would sound for the victim, Mr. Larry Dozier.
All right, Mr. Lyric Dozier. The Dozier. Nope. All right, go ahead. PD Cook.
Yes, Your Honor. My client's a lifelong resident of the Atlanta area. This is her dad, and it was spitting. I understand there's some other things that need to be resolved, or perhaps in her past, but she has 4 kids for which she is responsible that live with her, 4 minor children, and is on some government assistance. We would ask that she be allowed, because of the financial burden and because of her familial responsibilities, that she be allowed to get a signature-only bond at whatever level the court deems reasonable.
So we have that open cases with the same victim, correct, Mr. Walker?
Yes, they have at least one open case together, and that's the criminal damage to property. The other open case is out of South Fulton, so I can't see who the victim is on that matter. But the matter that's in Superior Court, that is the same victim. So they at least have two open cases together at this point. And there's another, like I said, third battery family violence out of South Fulton. I'm not sure. I suspect it's her father, but I can't confirm that at this time.
Mm-hmm. All right, I'm going to one last thing, Mr. Cook, did you say she is or is not working, although she has the 4 minor children?
She's not working at this time. She does have 4 minor children at home, and she's receiving some government assistance.
Do they live in the same location?
Yes, that's where they live.
Oh, well, she would have to find somewhere for her and the 4 children to go live.
Well, I've not talked to the father, but she does have 4 children she's responsible for, and that's where they live at this moment.
And this just happened, so we're not even 24 hours beyond this incident happening. I'm going to order a $3,000 signature bond through pretrial. Well, actually, pretrial probably would tell me no. Well, they said level 1 with the open cases, though. Pretrial, can you take her?
I believe that we would be able to take her. From my understanding, it was based upon the, analysis that we did that the level 1 would be okay.
Okay.
Yes.
All right, I'm going to order a $3,000 signature bond through pretrial. I'm going to order the 1-day anger awareness course. And level 1, no drugs, alcohol, weapons, or guns while on bond. No further contact with the victim, Mr. Lyric Dozier. And I'm going to order stay away from the incident location. I'll give her a one-time police escort to return to get her personal belongings, as well as to retrieve her children. And I guess that's it. Anything else, counsel?
Nothing else, Your Honor.
All right, thank you.
Next, we have position number 2, Ms. Edwards.
You said 2?
Yes.
This is 24 CR 000-372Y. Artrius Edwards, charged with this is abandonment dependent child support. So the only question I have is what's the purge amount?
So actually, Your Honor, it's not a child support case. It's a,
No?
yeah.
Oh,
I don't know
sorry.
if we tried
When
it,
I see those on there,
but
I think
typically
of,
it is.
yeah, usually. So let me slow down and go to pretrial, and then we'll let you present your case.
Okay. In this regard, Your Honor, the defendant has 4 prior arrest cycles beginning in 2008. And according to the GCIC, there were no prior misdemeanor convictions or felony convictions. And the defendant's last arrest was on April 18th of 2012 for battery, touch or strike, and that was in Sarasota, Florida. The defendant, according to my information that I have, would meet the criteria for a release level 1 with an 84% chance that the defendant will appear and an 80% chance that the defendant will remain arrest-free.
Okay, state.
Yes, Sean. In this case, law enforcement was dispatched to 5655 Old National Highway. From my understanding, there's a juvenile that this case surrounds with the initials AE. From my understanding, the father brought the juvenile to his mother's home, who is the defendant. The mother does have custody. She refused to let the juvenile into her home. Police were called, and they advised her what would the consequences be if she refused to let the juvenile into her home, since she was the custodial parent. And I guess she said she, quote, she'd rather go to jail than let the juvenile back into her home. At that time, a warrant was taken out. We are asking for a signature bond through pretrial services, no weapons, drugs, or alcohol while out on bond.
All right. Do we know the age of the juvenile?
Check my notes. He was,
I believe it's 14.
yeah, he's 14.
14. Okay. All right, go ahead, PD Cook.
Your Honor, the child is 14. He's been in court himself, according to the client, a number of times. He runs off continually and has threatened her, and it's just become a real problem for her. I understand he's in the custody of her of his dad now, and we would agree with the prosecution on the sentencing.
Okay. All right, I will, oh, I guess I'm gonna have the same issue again. This, now 5655 Old National, that's a business, or that's not the home
I
where,
think that's her home, but we're not asking for a stay away or no contact because she does have legal custody of the juvenile. So we're not asking for a stay away.
I guess my concern is if they're having issues and she didn't want to let the juvenile in, where's the juvenile now? And if I tell her to go back there, the police gonna be called again if she refuses to let this juvenile in. He has to have somewhere to go.
Correct. So I mean, obviously I can't speak to the future, so I hope she would not continue to lock the child out of the home. But
Mm-hmm.
presumably if that happened again, I mean, I'm sure the police would be called out to the location, but I'm not sure if Mr. Cook would like to chime in or
I know that at this point, the child was released to the custody of the father. I
Oh,
can't predict the future any better than anyone else on this kind of situation.
right. Well, that's good to know. He's released to the custody of the father, so maybe obviously the child now has some alternative living arrangements. That's what I was kind of making sure of, to not put them back in the same situation if we can help it. All right, I will order a $3,000 signature bond through, I guess I'm going to order this one through the jail. I believe we will still have the mother. She will come back to court. I'm going to let her go through the jail. No drugs, alcohol, weapons, or guns while on bond. And I'm going to say right now, no further, I'm inclined to say no further contact with her child so they can work some things out. I'm kind of glad to hear you can go with his father. He has somewhere else to go stay. Then my other
Your Honor, if I could chime in, it's
information,
my understanding that the father was going out of town and was unable to provide care to the juvenile, and that's why he was returning the son back to the mother because the mother is the custodial parent. I don't have the plans of the parents in going forward in the future, so I can't speak for
yeah,
the father or the mother, but I think that was the basis of this. The father had to go out of town and return the child to the mother, who is the custodial parent, and she refused to let the child into her home, even though she has custody of said child.
mm-hmm.
And the police even advised her of what would happen, and she said she didn't care. So,
If I order her to not have any contact, I guess is what she'll do. But I don't want to leave the child kind of out in the, out in the cold. Let me go ahead and say no further violent contact with the minor in case there needs to be some contact for living purposes. I'll just do no further violent contact, and I won't worry about any stayaways. And that's all I think I can order at this point.
Excuse me, Your Honor, can we go back to position number 1? What level was that through pretrial?
Level 1.
Thank you.
And I think this one is level 1 as well.
Thank you.
Mm-hmm.
You said 2? I thought he was going through the jail.
Oh, that's right. 2 is going to the jail. No
Okay.
level.
All right. Thank you.
Okay.
Next, we have position number 3. No, I'm sorry, 1 second.
Okay.
I'm sorry, position number 11.
Okay.
Ms. Patterson.
This is 24 CR 0000369J. Christina Patterson. Target 1 count of battery family violence, pretrial.
Your Honor, this defendant has no prior criminal history, and the defendant meets the criteria for UJR jail with a 91% chance that the defendant will appear and a 87% chance that the defendant will remain arrest-free. Nothing further.
All right, thank you. State.
Thank you, Your Honor. This incident took place on January 15th, 2024. Law enforcement responded to a verbal dispute at 396 Piedmont Avenue Northeast, Atlanta. Upon arrivals, officers spoke with a neighbor who wished to remain anonymous. She told the officers that she heard screaming coming from the 4th floor. Near the courtyard area, officers heard the noise and proceeded to apartment 4032, where they overheard an argument. Mr. Sequan, Sequuaan, Petaway, answered the door, told the officers that he and his girlfriend, Christina Patterson, got into a verbal argument. During the argument, he got in her face. She pushed him away, which may have caused Miss Patterson to scratch him. The officers noticed visible scratch marks on his neck and chest and blood in the chest area. Our office has been in touch with the victim. He stated that they are in a relationship. He and the defendant, they live together at the incident location. They share no children. The victim confirmed the events in the warrant and stated that this has never happened before. He is not in fear of the defendant. He's okay with having contact and that he wants her to return to the residence. He indicated he will be appearing in person, I think, or on Zoom today. The state is recommending a signature bond through pretrial, 1-day anger awareness course. We're still going to ask for no further contact with Mr. Padaway and stay away from the incident location, no drugs, alcohol, weapons. And we would like to sound from the victim in accordance with Marcy's law.
All right, I think I see Mr. Petaway on the Zoom. Mr. Petaway, do you wish to address the court today?
Yes. Good afternoon, Your Honor.
Good afternoon. Raise your right hand for me. I'm gonna swear you in first. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down. Are you in fear of Miss Christina Patterson?
No, I am in no way, shape, or form in fear of Ms. Patterson.
Do you want to have any further contact with Miss Patterson?
Yes, absolutely.
And you all reside together, is that correct?
Yes, ma'am.
Okay. All right, I don't have any other questions, any cross-examination by either counsel?
None, Your Honor.
No, Your Honor.
Okay. All right, thank you, Mr. Petaway. You can mute yourself and listen in to hear my ruling, okay?
Say that again. I'm sorry.
I said you can mute yourself and listen in to hear my ruling.
Okay.
All right, thank you. All right, go ahead, PD Cook.
Your Honor, we would ask for a signature only bond through the jail with no no restrictions. They've been together for 7 years and have lived together for 3 years. And that's all.
Does she work?
Let's see. Yes, she works. She does restaurant work and also does some healthcare work as well, which she's
All
been
right,
doing for about 3 years.
okay. So I do want to make sure that there has been the ample cooling down so that I don't send you all back into a situation where it either continues on or it's not had time to cool down some. Mr. Petaway, that would be my concern. But I will allow it. I usually don't. I usually try to wait a day or two. But if you think that you all can live together peacefully, I'll allow her to come back. I'm going to give her a $3,000 signature bond through the jail. I'm going to order no further violent contact with you. I'm going to order no drugs, no alcohol, no weapons or guns while on bond. And I think that'll be it.
Thank you, Your Honor.
All right.
All right, next we're gonna do position number 6 and 7. It's a conflict. Judith,
Okay.
Your Honor, did you enter a awareness class?
For who? 11? Yeah,
Yes.
she's through the jail.
Okay, thank you.
And just no further violent contact.
Okay, no problem. Thank you.
Mhm. And this is 6 and 7.
yes.
Okay. 24 CR 00375A. Jeter, I think that's Deja, 1 count of battery family violence from December 11th, 2023. And then I have a second case with Jeter and Mr. Jeter. That's another battery family violence from January the 15th, 2024. And that's 376A. Pretrial?
This defendant has one prior arrest cycle beginning in 2021, which was the defendant's last arrest on July 8th, 2021 for driving without a license. This defendant does meet the criteria for release level 1 with a 91% chance that the defendant will appear and an 80% chance that the defendant will remain arrest free. Nothing further.
Yes, Your Honor. In the first case, well, actually, in both cases, the victim's name is Miss Miosha Reese. Law enforcement was dispatched to their home at 681 University Ave. The defendant and her shared children together. She advised that they were having a disagreement over some food when the defendant became irate and struck her several times in the first case. Similar in the second case, they were having a domestic dispute when the defendant became angry and again struck her multiple times. In that case, the officer did observe bruising and a knot over the left eye of Miss Reese. The state is asking for a $2,000 surety bond in each case, a stay away from the incident location, no contact with the victim, Miss Miosha Reese, no weapons, drugs, or alcohol while out on bond, and I believe they will need third-party transfer of the minor children. And we would sound for the victim, Miss Reese, if she is on the line.
All right. It's Reese, Reese.
Yes, Your Honor.
I see a Miosha Reese.
Yes, that's the victim, Your Honor.
Reese. Ms. Reese? Do you wish to address the court today? Are you still there?
And I'm not sure if the victim's having a hard time, but I will say that we have had contact with her, and she does not want to have any contact with the defendant, and he will need a one-time law enforcement escort to gather his belongings.
Okay. All right, no, McLeod?
Yes, Your Honor. Good afternoon.
Good afternoon.
Mr. Jeter is 20 years old, Your Honor. He is currently employed. As pretrial has stated, he only has one previous arrest, and that was traffic related. Also, this incident happened, I believe, based on what the prosecution said, sometime in December. I would ask that my client receive a signature bond, Your Honor, preferably through the jail. He will need a one-time police escort to get his belongings from the location, and also third-party transfer of the 2 minor children that he shares with the alleged victim. I did have the opportunity to speak with Ms. Reese, and she indicated to me that she didn't want any further contact with my client, so I guess no further contact would be appropriate under the circumstances. Nothing further, Your Honor.
Okay. And I'll make one last call for Ms. Reese. All right, on the first case, position 6, that will be a $2,000 signature bond through the jail. No drugs, alcohol, weapons, or guns while on bond. And since this did happen back in December, that's all I'm going to order at this time. No stay away, no contact level would just be no further violent contact.
No further contact.
Wanted no
Period.
further contact. That's right. She wants no further contact. And I will order the third-party transfer of the 2 minor children. That needs to be facilitated by someone else. And I see Ms. Reese is on.
Yes, I was having difficulties to join.
Okay. And the other thing I would order would be stay away from the home or location of where Miss Reese is, since you don't want any contact with Mr. Jeter. Is that correct, Miss Reese?
Yes.
Okay. All right. And I don't know if we have your home address. If you don't want it as part of the record, you can put it in the chat because this incident, did it occur at your home, your location?
Yes.
So we have your address. Is that correct?
Yes.
Okay. So I'm going to order no further contact from the defendant. I'm going to order that our orders will say that he will stay 200 yards or 2 football fields away from you. He's not to contact you by email, phone call, text, social media, or anything. Have no contact whatsoever. And I hope you have a third person that can help to transfer the children if there's visitation that is allowed, so that he doesn't violate the conditions of the no contact bond, because he cannot have any contact with you. No drugs, alcohol, weapons, or guns while on bond. And then the second case, I'll do the same thing, $2,000 signature bond through the jail. Same conditions, since it's the same victim. No further contact, stay away, third-party transfer of children. All right, anything else?
No, Your Honor.
Okay, all right.
Next, we have, position number 13.
Listen. Your Honor, this is the one that I requested for breakout room for MH issue, Your Honor.
Okay. Who is it, Ms. Champion?
Yes, ma'am.
Oh, hi, how are you?
Good afternoon, Judge.
Yes, can you put us in a breakout for position 13? I guess
Yes, ma'am.
the PDs and the ASGs. And Ms. Holly.
Excuse me, Miss Lydia Kincaid?
She was having technical difficulties.
And who are you, sir? I'm sorry.
I'm her husband and Gabrielle's father.
Okay, I'm about to put you guys in the breakout room with the judge.
Okay. Let me see if I can get her back on.
Okay,
Can you hear me now?
okay, I'm about to put you guys in the breakout room when it comes up, just accept it, please.
Charlie, can you hear me?
Yes. Yeah, so they're gonna send you a breakout room message, just accept it.
Okay, I can't see anything. Should I close out then?
You don't see the message for the breakout room, Ms. Kincaid?
No, let me go to messages. Nope. No, I can't see, but you can hear me, right?
That's correct. Maybe you need to log out and log back in, and I'll send you the message once you log back in.
Okay.
Okay, with that. Courtroom 2, can you hear me?
Yes.
Okay. For Ms. Weiss, I'm going to enter a $3,000 signature bond for the jail. However, you'll see on the order when you get it that she's only to be released to her father, Dr. Charles Weiss, on Thursday, January the 18th. Between 2 and 4, give or take, or in the afternoon, sometime after 2. She will have an MHE order. It'll be scheduled for the competency calendar on February 1st. She's to have no further violent contact with her parents, either parent, Mr. Weiss, or her mother, the victim, Ms. Kincaid. And no drugs, no alcohol, no weapons, no guns while on bond. And Mr. Weiss will make sure that she gets that evaluation. Is there anything else that I've left out? And we'll have his number in the bond order, deputy, so that when she's ready for release, that he can receive a call to make sure he's there to pick her up, because she's only to be released to him.
Next, we have petition number 4, Mr. Glanton.
Oh, and Miss Holly, don't forget, can we put in there for pretrial not to revoke her first bond?
Okay,
Forgot about that.
okay. I have so much written on him. I'm trying to
I know you do. You squeeze it in.
Okay, I'm gonna do it. Give me just a second. I want to make sure her order is duplicated.
Okay.
And also the timing of her prescriptions,
I have it on here.
Your Honor. Okay, thank you.
Okay.
I'm ready, Your Honor.
All right. All right. Thank you, Mr. Weiss and Miss Kincaid.
Thank you.
All right. Thank you. All right. This is position 424 CR 000374J. Demario Glanton. Pretrial.
This defendant, Your Honor, has 10 prior arrest cycles beginning in 1996. The defendant's last arrest was on August 2nd of 2023 for a FTA. The defendant has 3 prior misdemeanor convictions and 4 prior felony convictions outside of the 10-year period. The defendant had a felony conviction in August of 2023 for possession of a firearm by a convicted felon. The defendant was sentenced to 7 years and 10 months on probation. It does appear that the defendant is currently on probation for that case. In 2022, the defendant had a felony conviction for possession of a firearm or knife, and that was during the commission of a crime, and also possession of a Schedule II controlled substance, possession of a firearm by a convicted felon, and a misdemeanor conviction for willful obstruction. And it did appear that the defendant was sentenced to 5 years probation. And it appears that the defendant is currently still on probation for that case as well. Also, the defendant does meet the criteria for release level 3 with a 79% chance that the defendant will appear and a 55% chance that the defendant will remain arrest-free. Nothing further.
Yes, Sean. In this case, law enforcement was dispatched to 7340 Toccoa Circle, where they spoke with the victim, Miss Lori Sutton. She advised that she was at the location, at which time I believe her and the defendant were in a relationship or are in a relationship. They were in a verbal disagreement, at which time he did punch her with a closed fist and hit her with a spatula. The state is seeking a $2,000 surety bond, no contact with Miss Lori Sutton, and stay away from the incident location, no weapons, drugs, or alcohol while out on bond.
All right. PD Cook, is this your case?
No, Your Honor.
Oh, PD Kim?
Your Honor, I apologize, but I only have one more person.
I believe this one is a conflict.
Oh. Did she get off thinking that was her only case? Is Ms. McLeod still on? We'll probably have to call her. Mr. Jordan is not here to call her.
Miss McLeod is still logged on.
Oh, she is still logged on. Okay, I can't see. Ms. McLeod?
I give her a call.
Okay, thank you.
Did she say she was still logged in?
Mm-hmm.
Yeah, she's coming on now.
Okay.
Good afternoon. My volume
Okay.
was a bit down, so I didn't hear.
Oh, it's okay. All right, this is position 4, Demario Glanton.
Yes, Your Honor, I represent Mr. Clanton.
All right. Do you want to hear the state's presentation again?
Yes, Your Honor, if it's not too inconvenient.
Okay.
Fine. In this case, law enforcement was dispatched to 7340 Toccoa Circle, where they met with the victim, Miss Lori Sutton. I have to correct the record. I said they were in a relationship. They actually are cousins and they reside together at this location. But law enforcement was called because they were having a verbal disagreement, at which time the defendant did punch the victim and then he struck her with a spatula. We have had contact with the victim. She's requesting no contact and to stay away from the incident location. The state is seeking a $2,000 surety bond, no weapons, drugs, or alcohol. And our request is, I'm not sure if Ms. McLeod heard the history of the defendant.
No, I did not.
It's quite lengthy, so I will let pretrial speak to that.
All right.
So this defendant had 10 prior arrest cycles, and that began in 1996. And the defendant's last arrest was August 2nd, 2023, and that was for an FTA. The defendant had 3 prior misdemeanor convictions and 4 prior felony convictions, and that was outside of the 10-year period. The defendant also had a felony conviction in August of 2023, and that was for possession of a firearm by a convicted felon. In that case, the defendant was sentenced to 7 years and 10 months on probation, and it appears that the defendant is currently on probation for that case. Also in 2022, the defendant had a felony conviction for possession of a firearm, possession of a Schedule II controlled substance, possession of a firearm by a convicted felon, and also a misdemeanor conviction for willful obstruction. It appears that the defendant is now serving 5 years on probation for that case, and the defendant did meet the criteria for release level 3.
Okay.
Thank you. Your Honor, my client is 44 years old. My understanding was that the alleged victim was actually his sister, but I believe the state said, Mr. Walker said they were cousins, but he told me she was his sister. He also tells me that they all live together in the family home. His grandmother lives there, his mother, it's a family home. He's always lived there. So he doesn't have anywhere else to go because he's not working and has not been working for quite some time. In fact, he tells me that he is very ill. Let me just put it that way. I don't want to go into all his HIPAA history, but he tells me that he is so ill that he's unable to work. So he is not in a position to find anywhere else to live because he doesn't have any money or the means to go anywhere else. I would ask the court to take that into consideration in setting a bond for him. I was not able to contact anyone in the family, although he did give me a number to reach out to his mom to speak to her about the situation. But so I would ask the court to give him a signature bond, condition no further violent contact with his sister or his cousin, whichever relationship there may be between them. He tells me it's his sister.
And I can clarify, Your Honor. Like I said, first off, we have had contact with the victim. She's requesting no contact and stay away. They are cousins, however, they grew up together, so they call each other brother and sister, but they are cousins, to clear that
Okay,
up.
well, he told me she was his sister,
Yeah,
so I was going on
get
that.
it. Yeah.
So she confirmed that they live together, and my understanding is that this house that they all live in belongs to grandma. And
Yeah.
mom lives there, and
And she also confirmed that she wants no contact and to stay away. So that's the state's position.
Well, our position is that he's always lived there with his mother and his grandmother. That's what he tells me. Also, based on what he tells me, he is very ill, so ill that he's not been able to work for the past few years because he has a rather debilitating illness, which I'm not going to go into here.
He wasn't too sick when he bopped her in the head, but okay.
He has a different version of what happened.
I'm sure.
Okay.
What position are we on?
4. 4.
Okay.
You're writing on a different one. All right. I will order the $2,000 surety bond. With that surety bond, I'm going to order stay away from 340 Toccoa Circle. I'm going to order no further contact with the victim, Lori Sutton. I'm going to order no drugs, alcohol, weapons, or guns while on bond. And I think that is it. No further contact and stay away. 2,000 surety.
Thank you, Your Honor.
Mm-hmm. What do we have next, Deputy?
Next, we have position number 3, Mr. Gates.
Okay.
No.
Mr. Gates. Not sure I pronounced the first name. 24 CR 0000373C. Charge at 1 count of battery family violence, pretrial.
Your Honor, this defendant has 4 prior arrest cycles beginning in 2014. The defendant's last arrest was on March 22nd, 2022 for criminal trespass. That was the defendant's last arrest. And the defendant was arrested in 2016 for battery family violence in East Point, and that matter was bound over to state court. The defendant had a misdemeanor matter under the First Offender Act in 2018 for marijuana less than an ounce, and that matter was sealed in 2019. The defendant does meet the criteria for release level 1 with an 84% chance that the defendant will appear and an 80% chance that the defendant will remain arrest-free. Nothing further.
Okay.
Yes, Your Honor. In this case, law enforcement responded to 340. I'll spell the street name BERACAH Trail, where they spoke to the victim, Ms. Courtney Ridley. She advised that her and the defendant were in a disagreement about whether someone was smoking in the home. At the time, the defendant did become aggressive with her and called the victim homophobic slurs. At the time, it stated that the defendant grabbed the victim and threw the victim and struck the victim several times, causing a laceration to her face. We have had contact with the victim, Ms. Ridley. She is concerned for her safety. We are asking for a $2,000 surety bond, a no contact, a stay away from the incident location, no weapons, drugs, or alcohol while out on bond. And with that, we will sign for the victim, Ms. Courtney Ridley.
All right. The victim is Courtney Ridley on the line.
Yes, ma'am.
All right, Ms. Ridley, do you wish to address the court today?
Yes, ma'am, I do.
All right, raise your right hand for me. I'm going to swear you in. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. Are you in fear of Mr. Gates?
Yes, I am.
Do you want to have any contact with Mr. Gates?
No, ma'am, I don't.
All right, I don't have any other questions of you. Do either counsel have any cross-examination questions?
No, Your Honor.
All right. All right, thank you, Ms. Ridley. You can mute yourself and stay on to hear my ruling. Okay. Go ahead.
Yes, Your Honor. My client is 27 years old. He's lived in Georgia all his life. He has graduated high school from Wheeler High School. He is self-employed and works at a family restaurant. He does deny the allegations as stated in the warrant. He's recommended for a UJR level 1. I'm requesting a signature on bond through pretrial services level 1. And that's due to the fact that he has very little criminal history. All I saw on the pretrial report was a 2020 criminal trespass. But I guess I didn't get the full pretrial report. But I would still ask for the signature bond through pretrial services level 1. And his aunt owns the property. I know that the complaining witness is living there, but has been evicted in the past. And she states that the complaining witness will be evicted. She's in the process of doing that, but still stay away and no further contact is fine for now.
Okay. Okay, and what about this location? Who lives there?
The victim resides there, Your Honor. And irrespective to who was evicted, who's going to be evicted, that's her legal address. That's where she resides. She stated that she's in fear. So we are requesting a stay away from that location along with a no contact.
Okay. I will order the $2,000 Oh, I had one more question. I'm sorry. Peter Taj, did you tell me she is or is not working?
My client is working 2 jobs.
Okay. I'm sorry, he. All right, I'm going to order a 2,500 signature bond. That signature bond will be through pretrial. I'm going to order the 1-day anger awareness course. Level 1, no drugs, alcohol, weapons, or guns while on bond. No further contact with the victim, Courtney Ridley. Excuse me. And a stay away from 3400, I believe, Baraka Trail or Baraka Trail.
It was
And,
340.
oh, 340. Okay. And I think that's it for now.
What level?
1.
Thank you.
Mm-hmm. That'll conclude this case.
Next, we have position number 8.
Okay. It's 24 CR 0000367D, Makiva Kadisha or Kadisha, charged with 1 count of criminal trespass and damage to property and possession of marijuana less than an ounce. Pre-trial.
This defendant has 1 prior arrest cycle beginning in 2023, and that was the defendant's last arrest, which was on May 27, 2023 for forgery in the 3rd degree. And that case appears to be open out of Barnesville, Georgia. The defendant does meet the criteria for release level 2 with an 84% chance that the defendant will appear and a 71% chance that the defendant will remain arrest-free. Nothing further.
Okay. State.
Yes, Your Honor, this incident took place on January 15th. Law enforcement responded to a domestic call at 5555 Roswell Road, Unit G9, Atlanta. Upon arrival, the officer spoke with Blessing Nwankwo, Nwankwo, who advised that she and her boyfriend, Mukiba Kadisha, had an argument during which he grabbed her iPhone 12, threw it on the floor, causing the phone screen to break. Mr. Kadisha had a backpack on when he was detained. The search of the backpack yielded a clear baggie of what appeared to be marijuana. Our office has been in touch with the victim. She stated that she and the defendant are in a relationship. They live together at the incident location. They share no children. She confirmed the events in the warrant. Stated nothing like this has ever happened before. She is not in fear of the defendant and would be okay with having nonviolent contact. She's okay with him returning to the residence. I do believe she'll be on Zoom. We are asking for signature bond through pretrial, 1-day anger awareness course, no drugs, weapons, alcohol, and if we can solve for the victim in accordance with Marcy's law.
All right. I think I wrote down tell me the victim's name again.
Blessing Nwankwo, I think I'm saying that right,
Right.
Nwankwo.
Right, I saw a Blessing line coat there. Miss Blessing Nwankwo, do you want to address the court today?
Yeah.
All right, just turn on your camera video for me. All right, I'll swear you in first. Raise your right hand. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yeah.
Okay, put your hand down, please. All right, are you in fear of Mr. Is it Kadisha?
No.
Do you want to have any further contact with Mr. Kadisha?
We can, but non-violent.
Okay. Do you all still reside together in this Roswell Road location?
I didn't hear that. What was that?
Do you still reside together in this Roswell location?
Yes, but I'm leaving.
Okay. All right, if there's no further cross-examination questions, that's all I have. You can mute yourself and still listen to the proceedings and wait on my ruling. And then I'm gonna let the PD's office present. Okay,
Your Honor, we would, my client has a completely different story, but we would be fully willing to forego a long discussion on what we believe happened. I will tell you that he is 31 years old. He is manager at Buffalo Wild Wings and Kroger. He has no family in town. He works all the time, as he described it to me. And he really needs to be able to get back into his apartment. His name is on the lease. I understand the law, and I understand if she's been there long enough, there are processes he would have to go through, but she says she's leaving anyway and does not fear him. I would ask for a signature bond at whatever level the court wishes, and allow him no restrictions as far as going back and living at the apartment. Obviously, no violent contact is no problem. That's illegal anyway. So we would have no problem with a no violent contact provision.
okay. I'm going to order a $3,000 signature bond through the jail. That'll be $2,000 on the criminal trespass and damage to property, and $1,000 on the marijuana less than an ounce. And I'm going to order no further violent contact between the parties. And based on this Blessing's testimony, I will say no further violent contact between the parties. No guns, alcohol, drugs, or weapons while on bond. And that's all I have.
Thank you, Your Honor.
Next, we have position number 10.
Okay. Is that Parker? Are you Quincy Parker?
Yes.
Yes, okay. 24 CR 0003688, charge at 1 count of battery. Pre-trial.
This defendant has 82 arrests, prior arrest cycle beginning in 1987. The defendant's last arrest was May 5th, 2021 for a marijuana less than an ounce. Outside of the last 10 years, the defendant has 17 prior felony convictions and 29 misdemeanor convictions. I saw no prior felony convictions or misdemeanor convictions within the last 10 years listed on GCIC as convictions. The defendant does meet the criteria for a release level 3 with a 79% chance that the defendant will appear and a 65% chance that the defendant will remain arrest-free. Nothing further.
Okay. State.
Yes, Your Honor. This incident took place on January 14th, 2023. Law enforcement responded to a person injured in a fight call at 865 Hank Aaron Drive Southeast. Upon arrival, Elena Andrews told the officer that she went to Mr. Parker's door to confront him about another woman, at which point he came outside. and started beating her, causing a cut over her left eye. He then put his hands around her neck, choking her, trying to take her over the second-story railing. The officer noticed a cut above Ms. Andrews' left eye and bruising around the front of her neck. Our office has not been able to get in contact with Ms. Andrews, but the state is requesting a $3,000 surety bond, one-day anger management course, no further contact with Ms. Andrews, no drugs, alcohol, or weapons.
All right, I forgot to sound for the victim. Do we have anyone on the call? I didn't catch the first name. I know Andrews was the last name.
Elena Andrews.
Okay. Elena Andrews. Go ahead, BB Kim.
Yes, Your Honor, my client is 51 years old and he was born and raised here in Georgia. He has all his family members here in Georgia, Your Honor. He has a strong ties. He's not going to run away from his responsibility. And Your Honor, he is actually, they do not live together. They have no kids together. They're just acquaintance. And my client is totally fine with a stay away from her place and no further contact. The current incident location is actually his place, and he's the only one who's on the lease, and she does not reside there. He has been active in the community. He was a coach for the football for neighboring kids. He is employed. However, because it is a seasonal job, he has not been able to make a lot of money from November until March. He will have a hard time to make incomes. So he's qualified for public defender services. He's working for Asphalt Enterprise. And Your Honor, he's also paying for child support. Quite a bit of money is going for his child support. So he's qualified for public defender. We would like to request for signature on bond through pretrial level 3 as he is recommended. Thanks, Your Honor.
All right. All right, I will order a $3,000 surety bond. And with that surety bond, I mean, the history is too extensive. I'm going to order well, I said $3,000 surety bond to stay away from 865 Hank Aaron Drive Southeast. No further contact with the victim, Elena Andrews. No drugs, alcohol, weapons, or guns while on bond. And that's all I'm going to order.
Your Honor, the location 865 Hank Aaron Drive is actually his apartment. He's the only one who resides there. His name is on the lease. She does not reside there, Your Honor. Can you go there with a law enforcement officer to verify that she does not live there and then return home?
Yes, I'll order that law enforcement escort to the property, sweep the address, make sure that the victim does not reside there. There are no belongings of hers there, then he can reside there.
Thank you, Your Honor.
Okay?
Yes.
Okay.
Okay, that completes our calendar over here in courtroom 2.
Can you tell us about Craig Washington, number 12? And number 5 is Michelle Holmes. Did those two bond out? I have another one, 9, Felicia McCurry.
Sorry, Your Honor, Michelle Holmes, position 5 is a waiver, and Washington, position 12, I guess I need a breakout room for that.
Okay. And then there was one more, the third one I thought I saw.
The position number 9.
Was it 9? Yes, who is that? Kalisha McQuarrie.
It was set from
Yes, Your Honor. I understand that she is a conflict.
Oh, is she? Is she a waiver as well, or do we know?
I don't know, Your Honor, because I have not spoken to her yet.
Yeah, those 3 individuals, it's my understanding they were all medically reset from Saturday's calendar. I was out for yesterday, so I would imagine they were probably medical resets today, but we would need an update from the jail if it's going to be another medical reset or what the status is. So
Right.
Ms. McCrary and Craig Washington, it's my understanding they were all medical resets stemming from Saturday.
They were reset from yesterday as well.
Okay.
Oh,
We need a
and
status on all 3 to see if it's another medical reset or what we're doing.
Right. All right, courtroom 2, still there?
Your Honor, we try to get these individuals to interview. It's pretty much a no-go.
Wow.
We tried, and I let Ms. Holder know that Craig Washington, he wouldn't even get up.
Okay.
So I don't know where to go at this point.
And then Kalisha McQuarrie's the same way?
Same exact way.
Okay. I haven't had any in a while to just refuse. I don't know if we keep resetting them, ASG Walker, or do I just give them a bond, or it's kind of
Typically, in the past, when this happened, a supervisor from the PD's office, I think they would try to take them to the cell and they would try to interview them through the door. I don't know the process because I'm not a PD. If we want to go into a breakout room and discuss it further, we can.
okay.
If you guys could order a social worker to come out tomorrow, I can take the social worker up there and then.
Right. Typically, a social worker or a supervisor will go and try to go to the cell and see. And if that wasn't successful, I think they would normally submit a competency evaluation.
Exactly.
Okay. Okay. So then you'll send someone up to McQuarrie and Washington.
No,
to
it's
see
3 and Holmes.
Oh, and Holmes, one more. I thought they said that was a
Well,
waiver though.
Yeah, Holmes is a waiver.
Oh, you were
Holmes
able
is-
to talk to her?
Yes.
Okay.
Okay, so Holmes is a waiver, so we're just down to 2, 9 and 12, and we'll get.
And I can
some-
clarify for 12, sorry.
Okay.
Oh, okay. Well, we'll stop the recording. We can stay where we are as opposed to a breakout. Okay. All right, so
What about the live, Your Honor, the live YouTube streams, or does it have to be?
stop streaming as well.